The people defer to the court. On the appropriate post-trial schedule that allows for adequate time to adjudicate Trump's motion while also pronouncing sentence, quote, without unreasonable delay. Now, the people, says the Bragg prosecutors, are also mindful that significant public safety and logistical steps by multiple agencies are necessary to prepare for court appearances in this matter. Oh, okay. So they just don't want to overburden the staff.
They say Trump could go to an appellate court and upend preparations for the sentencing, which are likely to be costly and complicated. And given that, they're throwing it back to Judge Merchan and saying, whatever you decide, Judge, we'll be ready.
Pathetic. Alvin Bragg and government prosecutors look like they're caving on the Trump sentencing. This is a letter that comes from Alvin Bragg's office. Of course, he's prosecuting the case against Trump out of New York. The judge there is Honorable Judge Juan Merchan. And this got sent to his office. So from Bragg, not really Bragg, we know who actually is doing the heavy lifting there, is not Alvin Bragg. It's this guy, Matthew Colangelo. Matthew Colangelo, Biden's number 3 at the DOJ before he resigned and went over here to prosecute Trump because he was the guy who was basically setting up Trump prosecution franchises all around the country. Went over to Tisch, worked with him, worked with Bragg, different office, same state, probably worked with many other prosecutors in speculation only in the Georgia case and in Florida, but didn't actually go and physically, handle those cases, but was the 3rd at the DOJ. You know who did handle those cases? Jack Smith, Jay Bratt, the rest of them, Molly Gaston. You think they didn't know each other? Come on. All right, so Matthew Colangelo is the person who is drafting this, and there is a big just backpedal on this, and it's outstanding to see. It looks like the sentencing is not going to happen, but let's see what the judge does with it. He could always dig in. So here is from the prosecutor to the judge. It says, Your Honor, this letter addresses Trump's prior letter that we read here that requests an adjournment of the sentencing date, which is coming up mid-September. So a postponement, a continuance, or a total adjournment, right? Get rid of it. We don't need it because we have to have another evidentiary hearing to discuss the immunity issues. The people defer to the court. On the appropriate post-trial schedule that allows for adequate time to adjudicate Trump's motion while also pronouncing sentence, quote, without unreasonable delay. Defer to the court. That probably hurt for them to have to type that. Because what you want to do is oppose. The people oppose Trump's motion. He's wrong, clearly. Sentencing should happen on this day. But they note the following points with this court. They say Trump's letter indicates, for the first time, his intent to seek interlocutory state or federal appellate review before he is sentenced of any adverse ruling. And it's like, oh my gosh, are you kidding me? What did you think was going to happen? That he would just lose and not appeal it? Well, this is the first time we heard that Trump could appeal this. We had no idea. Have you ever prosecuted a case before? Well, do you know what an appellate court is? Because that's what happens when people lose, especially on an immunity issue. And by the way, you should have had notice about this because they did the exact same thing in the January 6th case. We had no idea that this was going to be appealed. He just told us. Now, it's correct, they say, that the denial of immunity from prosecution is immediately appealable, like we saw with Judge Chutkan's case. So they agree Trump was right again on that one. But here, in contrast to Trump's case in Washington with Judge Chutkan, the J6 case, the question of Trump's immunity from prosecution is not presented. Okay, it's been presented this entire case. It was presented before the trial started, and it was presented multiple times in the middle of the trial. The judge even said, stop raising that objection. You don't need to raise it every time. The only question now before the court is whether a small subset of the trial evidence was improperly admitted in light of a brand new evidentiary rule that derives from official acts immunity. So this is the prosecutor right here throwing a temper tantrum. We had no idea. This just came out of nowhere. So they say, and if so, whether there's any error in admitting official acts evidence was harmless. So they're going to say that even if we put immune material in there, immune evidence, immune testimony, Hope Hicks, anybody else, the judge could also find it's harmless. So it doesn't matter. It's not that big of a deal. Didn't matter. It didn't prejudice Trump in some way. Now, and the court didn't say that, okay? The Supreme Court didn't come out and say, well, you can include it unless it's harmless. Like, that's not even in the Supreme Court decision at all. Now, as the people noted, the prosecutors are saying, as we noted, in our opposition to Trump's immunity motion, they say the evidence that he claims is affected by SCOTUS is only a sliver of the mountains of testimony. Well, only a sliver of it was, okay, maybe a problem, and the documentary proof that the jury considered. They had whole mountains of other evidence. And so we don't actually need to even consider these rules. Well, it's funny because the Supreme Court didn't say, well, it's okay if it's only a sliver. Then we'll accept it. It's not Judge Kagan saying, okay, only a sliver. No, that's not how that works. So it's total coat mode. This is pathetic. They probably feel pretty pathetic writing this, honestly. Matthew Colangelo, he's not a dumb guy. He's obviously orchestrated a bunch of different prosecutions. He's a corrupt guy. I would say an unethical person, but he is the individual who is failing so badly right now. I mean, you also got to just be totally embarrassed because your case is falling apart. Like, this was the last one. You're hanging everything on this, and he's having to sit here and just kind of make these sliver of mountain arguments. Wow. So we continue on. The Supreme Court's recent decision did not consider whether a trial court's ruling on the distinct evidentiary question is immediately appealable. Why wouldn't it be? And there are strong reasons why it should not be. Okay. Nonetheless, given Trump's newly stated position was an obvious follow-up to any denial of immunity. Clearly, it's not like I had no idea that they were going to run another play after that play. Well, have you ever watched this game before? We defer to the court on whether an adjournment is warranted to allow for the orderly appellate litigation of that question and to reduce the risk of a disruptive stay from an appellate court pending consideration of the question. And assuming that Trump seeks an interim stay of the sentencing immediately after the court's September 16th ruling. So remember, we got those 2 dates coming up. So 9/16 will be, it's like a status conference, right? They're going to come back and, well, what are we going to do about immunity? Then they came back on 9/18, and there were prognostications that for the sentencing date, that this would be when, right, Trump, if he sentences him to prison, he goes into custody that day. And generally speaking, if you're not the president, if you're not in the middle of an election, generally speaking, you're, everyday civilian citizen, you're sentenced to prison, you're going. So the status conference will be here. Let's say the judge comes out, right, and says, well, no, you're not immune. There's harmless error. I am as corrupt as everybody speculates, and I'm just going to totally ignore the Supreme Court or whatever. Then Trump would appeal that. So this would be stop. Now it's blocked. You go up to the next level court. This is stayed, okay, just by virtue of the operation of the law. And so the prosecutor was basically acknowledging that. He's like, look, this is going to happen, whether we want it or not. I know this is the rule. This is basically what happened with Chutkins. Now, they tried to be pretty clever about this, scheduling these two things back to back. Trump obviously asked for an adjournment of this date. Just get rid of it because we're going to appeal it, obviously. Now, the people respectfully note that the appellate court, considering such a request, will understand that without an interim stay, it would have to receive briefing and decide certain issues of the first impression in 1 day, right? So now you're only going to give them the 17th to make a decision on this. So they're like, all right, we were trying to be cute, but we're kind of, limiting ourselves here. The people are prepared to appear for sentencing on any future date as the court sets. Now, the people, says the Bragg prosecutors, are also mindful that significant public safety and logistical steps by multiple agencies are necessary to prepare for court appearances in this matter. Oh, okay. So they just don't want to overburden the staff now. That's really nice of them to be so considerate of the staff. The defendant's newly stated position concerning an immediate appeal, like, what do you think he was going to do? Don't act so surprised. May mean that significant preparatory steps are taken only to have such steps disturbed by appellate litigation. So in other words, Trump will appeal it. It'll go right up here immediately. The appellate court will put a stay on the sentencing. Meanwhile, everybody's prepared to come in on the 19th. Like, oh man, we don't have to come in? No, it got moved. Oh. So none of the defendant's remaining arguments merit any consideration. We're not going to talk about them. First, although couched as a scheduling request, Trump re-raises for the 4th time a recusal grievance based on false claims. And this was great. Trump did do that, and it was really funny because he says, Judge, if you just get rid of the sentencing and allow us to come back here and actually have a fair case, we won't even worry about recusal anymore. So they kind of threw that in there as a jab. It's like, we know we keep hitting you with this. Like, you should recuse because you donated to Joe Biden, should have recused because your daughter worked for Joe Biden. Now you should have recused because your daughter worked for Kamala Harris. Judge also made nasty statements about Trump to his daughter. She talked about that on a podcast. Like, the list goes on and on. So we'll stop telling you to leave if you just do the right thing on this case, right? And just move this sentencing based on false claims of a potential conflict that have already been rejected over and over by this court. He's like, Your Honor, you're amazing. You're so good. I'm sorry they're attacking you. The First Department and the Advisory Committee. Now, Trump's ostensibly new argument about the court's family members' co-workers' tweets is bizarre. And that dude did post a bunch of tweets. What's so bizarre about that? And nothing to do with the post-trial schedule. Well, Trump's concern about a public sentencing submission from the people is also misplaced. So the loser government is going to submit their pre-sentence memo, and I don't know if this is standard, where it would be sealed in New York. I don't know if that's standard in New York. The only way the memo would become public is if the court orders otherwise or the defendant unlawfully discloses it. Now, finally, defendant's apparent insinuation, Trump's insinuation that state prosecutors are incapable of applying federal constitutional law is fundamentally flawed, given that the people, the prosecutors, and this court protect and apply federal constitutional rights every day. Based on the foregoing, the people respectfully defer to the court on the appropriate post-trial schedule. Okay, he can't come out and say, I agree with Trump. I agree with the defense that this should be stayed or adjourned because our case is crap and we tried tried to rig it from the very beginning, and we lost. We ran out of time because we tried to hurry, but we couldn't get it done before SCOTUS came back down. So they have to say we respectfully defer. Now, what does this mean? Okay, now we have, it's like the judge is supposed to be neutral. Okay, supposedly that is his posture, and he shouldn't have a position on whether this sentencing goes forward or not on this date in particular. What's his urgency from a judge's perspective? Is it judicial economy? Is his schedule so busy the following months? Can he not postpone this until after the election? What's his justification? Safety of everybody? No, you've got gag orders in place. Nobody's going to die any minute. So relax. Why don't you just postpone this? What's the urgency? What's the hurry? Now, the hurry ultimately here has been provided by the government, Matthew Colangelo and Alvin Bragg, racing this case to trial because they need Trump to be a convicted felon. I know they keep throwing that word around very loosely, but Trump, as we are seeing, is voting, right? He's not actually showing up on criminal records as a convicted felon, right? We're not seeing that anywhere because he's not a convicted felon for all intents and purposes. And what they're trying to do is get that done. But now they're going to defer. It's pathetic. They're losing. They know they're losing. Matthew Colangelo is just one total pathetic loser failure. And that's my technical opinion, so it's not name calling. But here is what MSNBC is saying about this. They posted about this after it happened. Let's see if they're upset.
From New York, where the Manhattan District Attorney's Office is responding to Donald Trump's efforts to delay sentencing in his New York hush money case, which right now is set for the 18th of September. MSNBC legal correspondent Lisa Rubin is with us. Lisa, good morning. What did the Manhattan DA's office have to say?
Manhattan DA's office had to say a lot on one hand and not much of anything on the other. First, they're telling Judge Merchan that essentially they'll defer to whatever he wants.
Pathetic.
But then they flag a number of issues on both sides with respect to Trump's request to delay the sentencing. On one hand, they take umbrage at a number of points that Trump raises in his letter that appear to take potshots at the DA. But substantively, they are acknowledging that the Supreme Court's decision doesn't have a lot to say about whether evidentiary rulings about immunity are immediately appealable. And
Obviously
given
it
that
is.
the sentencing is scheduled for just 2 days after Judge Merchan is scheduled to decide whether to set aside the verdict on the basis of those evidentiary rulings, they say Trump could go to an appellate court and upend preparations for the sentencing, which are likely to be costly and complicated. And given that, they're throwing it back to Judge Merchan and saying, whatever you decide, Judge, we'll be ready.
Pathetic. Cowards, man. They were racing to save American democracy. They needed to get Trump convicted so quickly or else we were all going to die before the election. Trump stole 2016, they claim. Now he's going to steal 2024. Oh, no. And then they just defer. Oh, man. So spineless. Stand by your decision. Bragg, Colangelo. You guys get it all the way to the finish line. Man, the left must be very upset about this. Trump's going to get away with it again. Oh, they're going to have a meltdown. Oh, it's going to be so fun to watch. We're going to be here continuing to cover it. Thank you for subscribing as we do.